Welcome everyone to this new episode of the Privacy Rules Privacy Espresso series. The episode of today is a bit special because we are not going to speak about a specific topic or case, but we are going to speak about work that the Privacy Rule team has created jointly, in particular involving 7 different countries in a row. That is related to M&A in the privacy and data protection sector, M&A transaction, of course. And we are going to discuss about it with Kelly Dickson from our Australian law firm, Macpherson Kelley, because as chair of our business development committee, she was the one that was handling and managing the entire process and activity. So we would really like to thank Kelly for that and also for being with us today. Hi, Kelly.
Hello, Alessandro. It's good to talk to you again.
Our pleasure, as always. And let's delve a bit on topic and these articles. So I think that my question would be, you know that a group of members you've been working with has published this article related to M&A and transaction. Why do you think this was necessary?
Well, we've been talking about this at various conferences and between all of our organisations. And so there was this group of Privacy Rules members who decided to write an article about privacy considerations in mergers and acquisitions, so in sales of businesses. And we just thought that in that sort of activity, there's always a lot of competing priorities. You're negotiating on the price. You're trying to work out which employees you're going to keep and which ones you're not. Sometimes the business needs to get competition clearance or antitrust clearance. You're dealing with issues like secrecy to try to keep the deal quiet. And that's often done under a lot of time pressure as well. So we thought, sometimes in these, the privacy and data protection aspects sometimes are either forgotten entirely, or they're only given a very cursory consideration, or they're left for too late in the process, and it can cause some problems for that M&A transaction down the track. So privacy might be considered by some to be a bit of a boring issue when you're doing all of the excitement of buying or selling a business. But it is really important. And if you do these things wrong, sometimes you can't use the data for the purpose that you want to, or it can result in some bad publicity and customer complaints and things like that. And in some circumstances, even regulatory outcomes like fines or investigations.
That's very interesting, Kelly. Thanks a lot. And I think that, also under the last perspective in particular, it's relevant to mention that, we have been considering countries very far one from the other. We have members from Colombia, you from Australia, Hong Kong, and members from Brussels for the EU. So, we really have a broad range and different perspective from different experts that are related also to different laws that are involved, because when you speak about it, there are different privacy laws with all their requirements to be respected. In that regard, who do you think is the right audience for such an article? Who should be interested to read it?
We were very keen to put this article together for in-house legal counsel and for people who work in businesses who are working on mergers and acquisitions. So we wanted to make sure that we could get some information to people who are working on these matters in real life and just help with a little bit of practical advice and guidance for them. We also thought that as privacy practitioners, we deal a lot with privacy and data protection, and that is one of our key areas of focus. But for a lot of other lawyers who work and advise on M&A transactions, they sometimes don't appreciate that the privacy laws around the world can be so different as well. So I think that there's some good guidance for other lawyers who work in M&A and other areas of law as well. But in our article, we have deliberately included some practical tips and tricks and some case studies just to help people identify, first of all, and then be able to navigate through and resolve some of the privacy and data protection issues that we see happening quite a lot.
Okay, and given this practical approach you have in particular in the second part of the article, can you give us a preview on which are the key takeaways people should receive through the article?
Yes. Yeah, so for me, I think that the key parts are that our article contains a list of common red flags that should be identified and resolved as early as possible in the due diligence process. We also make some comments on a range of representations and warranties that we should see in M&A contracts. Now, with that, they are different, because if you're the seller, you want different representations and warranties than if you're the buyer of that particular business. So it depends what side you're on. And we've also included some very detailed and practical, a bit of an example, a structured approach to how businesses can progressively share information as the deal progresses. And that's to hopefully help businesses minimize the risk of data breaches occurring. Finally, a really critical part is that once the deal is done, once the money's been handed over, once the champagne has been popped, there are still a lot of privacy and data protection matters that need to be dealt with. And that is the integration of that business, perhaps into the existing business, and other regulatory and compliance issues. So once the deal's done, it's not all over. And we've included a specific case study from Hong Kong where that went wrong, with some very notable consequences.
Okay, that's amazing. It's gives us an idea on how complex is this sector, and the fact that, you know, privacy compliance, data protection compliance is a constant process, not something that you do just at the beginning or at the end. So and you know, we are witnessing more and more regulation that are underline the fact that companies should constantly keep an eye on these. So Kelly, thanks a lot for giving us this you know, brief overview on the article. Of course, I invite all our listeners to read the article to know more, and to contact us if they have any question, or Kelly directly in particular for Australia, or any other of our experts joining the document. We will be always happy to help in M&A transaction, and of course in everything involving privacy and technologies. So thanks a lot, Kelly. Thanks to our audience, and I really look forward to meeting you all with our next Privacy Espresso next week. Bye, Kelly, and bye, everyone.
My pleasure. Thank you. Bye.